and I think we have you here.
Okay, because I can't do it. My
Which
fingers
one is-
don't reach that long.
Tell me what it's called.
Who knows?
There you go, right there.
Okay.
Good afternoon. I have a PowerPoint because I got the memo. Memo said, if you have PowerPoint, bring it. And it gave me a chance to use the new logos, so how'd I do? It's a pleasure to be here. Thank you, Jessica. I am excited to hear what the people on the other side of the city on Metro have to say. So my PowerPoint was just really to generate some discussion and to bring up the issues without giving any particular answer, although I probably have bias, because I can tell you, as we discuss this, what our ethics committee would likely have said. But here are some of the issues. When we're thinking about basic principles of medical ethics, I just wanted to review that we think about things like autonomy, we think about justice, we think about beneficence and non-maleficence. So those are the things that an ethics committee would consider when a case would come before us. There are some specific issues that are related to women's health and reproduction and pregnancy that I think are particularly relevant here, obviously. So here's some of the issues that I thought that we should consider. And I made these slides last night, and as I told Jessica, I was sort of doing it with the Academy Awards behind me. So if ever it says, as she said, I'd like to thank the Academy, that was a typo. So here, what I don't know that you know, but you may already know since you're all dealing with the law, that pregnant women in Texas and 31 other states essentially have no right to a living will. So that's one of the issues here. Because by virtue, at the moment you become pregnant, women's rights to have their living will sort of goes away. And that, oh, by the way, this was the Ohio law. So I thought I would, even though this was Texas, I thought since we're all in Ohio, we might want to know, well, is it any different in Ohio? And the answer is no. So a second issue to consider is viability. So viability is sort of the key catchword and the critical issue in lots of cases, but particularly here. So in Ohio and certainly in Texas, the fetus is not considered viable, which means it cannot live on its own outside the womb prior to somewhere between 22 and 24 weeks. And viability is typically the line, and I think you wrote a paper about the line in the sand. So it is the line in the sand after which termination is only legally sanctioned if the woman's life is in danger or some extraordinary circumstances. And we know that even Roe versus Wade did include, with respect to the state's important and legitimate interest in potential life, the compelling point is viability. So even back in '73, viability was an issue. Viability was longer than 22 to 24 weeks at that time, but still it was viability. So Texas abortion law, which is one of the nation's most restrictive, considers the importance of viability in a negative sense. So it does allow for late-term abortion. It does. But only if determined that the fetus is a condition that, regardless of the provision of life-saving medical treatment, is incompatible with life outside the womb. So that, I think, is going to be an issue we need to discuss, right? And can you just sort of keep these in mind? Because there are two issues here. One is, given her status as dead, clearly, if they turned off life support, the baby or the fetus, would not be viable outside the womb, although it was approaching that time frame in that 22 to 24 weeks. But at the time she died, the abnormalities, which the fetus did. So, as I had considered, the fetus's condition was likely incompatible with life, and which was interesting that Ms. Munoz and the fetus were in similar circumstances, and that they were continuing life support despite futility for both. So, in this case, I was considering whether the ethical principle should be the same as those employed by physicians whose parents make medical decisions for their children, such that Mr. Munoz, father, would have the same rights as other parents to choose whether to discontinue care for his unborn fetus that had a terminal medical condition, which would be in contrast to cases where parents refuse treatment for a treatable condition. Or do we look at this, for example, in the case of women who refuse a C-section, despite the fact that that would be incompatible with survival for a fetus? Professional organizations, ethicists have struggled with regard to guidelines regarding viability and fetal development, but basically, in most cases, hospital officials, physicians simply let the family decide, and the family had decided. And then the other issue to consider is Mrs. Munoz's condition. She was, by definition, dead, and death is defined as irreversible cessation of circulatory and respiratory functions or irreversible cessation of all functions of the entire brain, including the brainstem. So she met the criteria for being dead despite being on the ventilator. So as Lawrence McCullough is quoted from Baylor, which is in Texas, he says, "This is a pregnancy in a cadaver, and thus it's an experiment done for the benefit of a fetal patient. So it is considered experimental and therefore should have gone through an ethics committee, and the whole procedure itself was not sort of standard of care." The other factor to consider is, but there was no detriment to Mrs. Munoz to keep her going, despite the trauma to the family. There was no detriment to her since she was already dead. No harm, no foul. And therefore, there was no trade-off in terms of maternal-fetal risk or maternal-fetal conflict, which is often the case. And that was all my sort of ethical issues. That's all I had today. So I thought that would be plenty to discuss.
Do you have an idea? You have to go. Do you want to go next? Or you go.
Okay. I won't repeat what was just gone through, but a couple of things to supplement. One, I think it's really interesting that in this case, though it was a sensational case and received a lot of publicity, one could argue that the case is actually a little easier because you have somebody who is declared dead, and you know, I would argue that it's a more egregious wrong to maintain against her wishes a woman on life support because she is pregnant than to maintain somebody on a breathing machine, a ventilator, and other types of what we usually call life supports, so that a fetus can continue to grow and develop when that somebody is actually dead. So you get into corpse treatment issues rather than, you know, the kinds of rights of person issues that one would think would be more weighty, actually. That's one piece that struck me. Another thing that I thought was really interesting in the case is that if you compare, say, this statute, which is the important one for the Texas case, the Statute on Advanced Directives. The short title is Advanced Directives Act. The longer title you've seen out. It's only this thick if you print it out, you know, in sort of normal points. But if you look at when I just searched for pregnant in the statute, and there's the two places. Revocation of advanced directive when it comes to life support, and in the other is the straightforward, you know, that you will not remove life supports on a pregnant woman. Look at Ohio's, which was put up on the screen for us, and what you have in Ohio is, yes, the revocation piece, unless, but life supports might be withdrawn on a pregnant woman, and we don't address the brain death issue, which was a nifty way out for folks in this case, at least in the judiciary, I think. But we do say threat to life of the mother is a reason to withdraw or threat to the well-being of the mother. So you could determine treatment, go in a different direction based on that. And the other is a non-viable fetus, and that just has to be determined by 2 docs. And this was 14 weeks when poor Mrs. Munoz was found, and 22 weeks when life supports were withdrawn, because it took 2 months of basically of litigation. The brain death determination was 2 days after she was brought into the hospital. So it was something like November 28th. She was brought in November 26th, and she was withdrawn from life support January 26th. So those are 2 things that I would add to for discussion points.
Hi, Kavita, Arora. I just have a few points as well. So clearly Mark and I didn't get the memo, so we don't have slides. So this is just sort of what we have. I have a piece of paper. In any case, so adding to some of the issues that Dr. Kingsberg brought up was whether and to what extent we're okay with women being objectified. So to what extent legally will we allow women to be treated as just vessels or incubators, as was often, the headlines on CNN, et cetera. Second issue is, to what extent are we okay with state laws invalidating Roe v. Wade? So Roe v. Wade gives you any woman the right to a first trimester termination. Are we saying that women on life support are no longer allowed to have that same right, or can we have their advanced directives invalidate this right? So when Ms. Munoz was found down, she was 13, 14 weeks, and certainly, as Dr. Kingsberg brought up, even in the state of Texas, had the right to a termination. 3 would be the issue of medical futility. So all of her doctors agreed that she was brain dead. Her doctors agreed that her fetus was non-viable. And so to what extent are these advanced directives holding and tying physicians' hands in cases where they feel the care is futile and normally would be able to act accordingly after discussion with the family, which in this case, we're all on the same page that care should be withdrawn. And then finally is the question of who pays. The family didn't want this care. Who's stuck with the bill? And if the baby, in this case, this wasn't the case, but if the case was different and a baby was born and was born likely prematurely requiring NICU bills, who would pay for those multi-million-dollar bills? And is it really fair to stick a family that didn't want any of this care with those bills?
We should probably throw out that we had hydrocephalus, probable cardiac anomaly, and lower limb extremity deformity. So, as was pointed out, very likely, or at least arguably, a non-viable fetus, even if it was further along than 14 to 22 weeks, as it finally ended up. But
and suffered an anoxic insult
on
early in
top.
gestation for
Yes.
a long time.
All right, so we're going to open it up to questions about anything you would like to ask the panel to expand on and some of the issues that they brought up, or if there's any particular details that you want to talk about.
Go ahead.
Oh, I'm sorry.
So maybe I'll take this question. So as long as the fetus is getting nutrition and oxygen via the maternal blood supply, the fetus can continue to gestate. So actually, they've done studies in anorexics and bulimics. It doesn't actually take much PO intake to allow a fetus to keep going. And so as long as she was getting IV fluids with some sort of nutrition, even just sugar through her IV, that would be enough.
Well, wouldn't there be a big difference in the development between a fetus in this situation versus a fetus in a normal woman?
So in a situation of starvation or a situation of hydrocephalus? Sure. So the hydrocephalus alone, there's different categories, but physicians had deemed this to be incompatible with life and then had other severe congenital anomalies. So yes, the physicians there thought it would be incompatible with life.
And your question about whether the gestation of a fetus in someone who is brain dead, we don't have a lot of data on that. We don't tend to gestate fetuses in brain dead people. So to the extent, and this was Professor McCullough's point about, this was in essence an experiment. We have data that shows that if you could keep the blood circulating and make sure the fetus continued to get oxygen and continue to get nutrients, our evidence showed it should continue to develop. Would there be additional anomalies? We don't know, because we do not tend to have that situation. So that part is uncertain, even if we assumed a completely healthy fetus under those circumstances that didn't also suffer, because as soon as the Mrs. Munoz lost consciousness, and then actually her heart stopped beating and she stopped breathing, that lack of oxygen also affected the fetus. But if you could have all of that away, we still don't know the full answer to that. And I think that was part of one of the interesting questions that came up in this case. Yeah.
Why didn't the Institutional Review Board, stop the whole process when they found out the lady was brain dead? Because I think the purpose of the IRB is to prevent things like this from happening. Why didn't the university or the hospital stop it?
I can guess. Their legal counsel is saying, look, we're legally bound to continue with what we normally call life supports, even though she's dead. And they were clear, I think the legal counsel's name was Thompson, that they weren't trying to make a statement, didn't want to be in the news, but they wanted to comply with law. They weren't even trying to be a test case. I think had they wanted to be a test case, they would have not continued with life supports. They would have withdrawn and let the baby die and then see what happens. But the other reason is that this was a sort of rogue research study, if you take McCullough's view, with an N of 1. And although it's probably not so circumspect to say it, this does actually happen. I'm not talking about with say a brain dead pregnant woman, but you'll get people who you use. I have a friend whose dad was given gemcitabine, which is a pancreatic cancer drug for liver cancer, and it was clearly an N of 1. It shouldn't happen, but it does. And so I think the IRB here, where legal counsel had already taken a stand, would have been pretty reluctant to jump in and say, hey, wait, this is unregulated human subjects research. We should stop this. That's my guess. Yeah.
I think it might need to be turned on. Thanks.
So I think that one of the things that I think Sheryl said is that most hospitals would go ahead and prevail and withdraw. But to me, it raises an interesting issue about location. So obviously, what Texas might do and California might do, vastly different things. But also, even within a state, so we know that we have some similar restrictions in Ohio, and here in northeastern Ohio, we have a strong bioethics community and large hospital systems with sophisticated law departments and legal departments. So I think what we might do in northeastern Ohio would be different than what a hospital system in Canton even, or Coshocton, or certainly in Cincinnati might do. And I think that raises an interesting justice issue, even within the same state. Or even, like I said, if we went to a small hospital, that fear issue may mean a patient, though again, arguably she's dead, so she wasn't suffering, but the patient's, the dignity issues remain, and the patient's family is suffering through this and had to undertake a really public stance. And I think that that's a challenge for me, and I was wondering if any of you would like to comment on that.
Like you're the psychologist.
Well, given that Ohio is one of the 31 states where once you are pregnant, you no longer have a right to your living will, I think that would hold true in Northeast Ohio as well as Cincinnati. However, it is usually, as I said, up to the family, and that the hospital usually complies with those wishes.
Well, I would just say though that I think that that one wasn't really working anyway. So I think that the fact that if you look at some of what the legal opinion said, which was that part of the living will statute, or the advanced directive statute, doesn't apply to a dead person. I think that we would be getting that from our legal team
Yeah.
in
Yes.
One of, go ahead.
No,
One
I
of the,
agree.
I don't know that you get that in that small hospital in a rural setting.
you can ask 5 lawyers and get 5 different answers. You can ask 5 ethicists and get 5 different answers. It depends on the question and the indeterminate nature of the question. But I think your point about where you are making a difference is true. Viability, are you viable in, rural Ohio at
Right.
21, 22 weeks, or are you viable at Rainbow or Metro? These are really different. I think one of the things that's interesting about the Texas statute is it doesn't say, it says a pregnant woman. And, the way out of this was, oh, she's dead. So she's not really a pregnant woman. But it doesn't say a live pregnant woman. It doesn't say a pregnant woman with the rights of persons. It just says a pregnant woman. And I think on the face, it's easy to see why legal counsel at this it was called, what was the hospital? John Peter Smith?
Yeah.
What a great name for a hospital. Tom, Dick, and Harry Hospital. It was on the face, it's easy to see why they made this interpretation. I think it would have probably been wiser not to and just hope nobody made an issue of it, but whatever.
Further compounding the difference by location is, out of all of the states that have invalidated advance directives for pregnant women, they've all done it to different degrees. So there's some that do it completely, like Texas does. There's some that sort of give wiggle room and have 1 or 2 physicians have to agree that this is, a brain dead woman, that this is not a viable fetus. And there's others that kind of mirror Roe v. Wade, saying that this is only invalidated after the 2nd trimester or after viability. And in the 1st trimester, a pregnant woman still has the right to a termination. So this further compounds the issue of where a pregnant woman is brain dead.
So I'm going to just ask a question of the panel, just to clarify. One of the things I thought was very interesting about this case was she was in fact brain dead, right? So unlike the other cases where we've ever had the question come up, where you're thinking about an advance directive, you have either a woman who lacks capacity or possibly in a persistent vegetative state, but there's no question is actually living. How much do you think that confusion of what is brain death led into this? Because by definition, she was dead. And in fact, there are a number of things you do with a dead body, but you don't usually continue them in a hospital bed. The money issue is also interesting here, sort of who's paying for it. Your insurance policy does end when you're dead. Health insurance does a lot of things, but it doesn't continue to provide you benefits after you've died.
Having dealt with a number of cases just involving brain death, I can say, at least on that sort of anecdotal basis, that there's a great deal of confusion surrounding it, and it is very common for health professionals, when a patient is diagnosed as brain dead, to turn to a family member or surrogate and say, okay, so is it okay for us to withdraw life support? Which of course immediately says to the surrogate that they're not dead. It's not what's intended, and you are in a tangle. What probably should happen, and what I would counsel, is you turn to them and you express your sympathy and sorrow and support, and that's it, because you don't have an obligation to continue life supports on the non-living.
I think it's a psychological discomfort with people telling family members their family member is dead. And so it softens the blow by saying you're brain dead. It's sort of like, your cat's on the roof and we can't get her down, that your cat's dead. So I think that's part of it, and I think it probably should be removed from our terminology.
Now we have a colleague, David Arias Rodriguez, who did a study giving scenarios of withdrawal of life support in the brain dead to health professionals at Metro and UH. I believe those were the 2 places. And the responses are really interesting. And I think even at these major medical centers where there's a certain facility in dealing with these kinds of cases, there's, from the responses, some real confusion about, whether someone's really dead or not. And, our department chair, Stuart Younger, would be more comfortable, I think, with as good as dead when it comes to brain death. But for clinical purposes, we can't go down that road. But
so I wanted to go back to this viability issue that we were discussing earlier, and I don't know I've looked at Ohio statute, I haven't looked at other states, and I don't know how similarly worded they are, but one thing that I thought was interesting and troubling about Ohio statute is that it says, I forget the exact language, but the language about if the fetus could not be born alive, basically, doesn't tell you whether they mean at that moment or ever, right? So it doesn't, if she's 12 weeks, but there's nothing wrong with the fetus, right? And then does she, do you have to keep her on life support until, such point as the fetus is viable? So, and I looked, I know Ohio's, it hasn't been, there isn't a lot of case law on these sorts of things, so I don't think it's been resolved with Ohio. I don't know if you have a sense of how other jurisdictions read their laws or.
So I think compared to Texas, there's definitely some wiggle room in that aspect. Now, wiggle room to a clinician is probably murkiness to a lawyer, so you could see it, in two different ways. But that being said, it also is sort of in the middle. There's other states that explicitly say by trimester or at the point of viability and make that much more clear. So I'm not sure if this wiggle room was intended, and my guess is, knowing some of the other reproductive ethics statutes in the state of Ohio, that it wasn't intended, because we don't tend to do that, but who knows?
I love the wiggle room, and I'm glad that it's not clear as to whether is it the healthy 14-weeker, because a 14-weeker in this case is just not viable. And I don't think it would be very hard for us at Metro to have two docs say it's not viable. On the other hand, if what they really wanted was, well, if the fetus is otherwise healthy, then, well, that's a different statute. We don't need to tell them that, but you'd have to write something a little different. I think in general, I used to teach legal reasoning and philosophy of law. And you know this, hard cases make bad laws, right? But when we try to capture every different little scenario in law, and we leave little discretion, it's like the mandatory sentencing stuff. We end up doing ourselves a horrible disservice, because we will inevitably get the case that makes what we legislated look ridiculous, because it is probably. But
Well, let me just respond by saying I agree, but the flip side of that wiggle room is, of course, it's all well and good to do what you think until you get sued, or
Yes.
until you get, right, and then you find out what the law meant, or until you get prosecuted if, there were criminal penalties. So.
Other questions?
So I guess one of the things that I'm confused about is a point that you raised about how there are state laws that can kind of underride Roe v. Wade, and like how that functions in the advanced directive way. It seems like that's like not allowed. What are your thoughts on that?
So I'm not a lawyer, but I would agree, that seems like it's not allowed. My rudimentary understanding of the law is that the Supreme Court trumps states, but I would leave that to the lawyer to tell.
I'll answer that. And so I think part of the problem here is that Roe v. Wade, and in fact, this was arguments in other contexts of advanced decision making too. So in essence, Cruzan also looked at this issue, which was, if the individual is not in fact making a choice, are we protecting any sense of autonomy to let somebody else make the choice for them, even if what we're doing is looking at their advanced directives for indications of how they should make it? And so the undermining is not a direct, like, well, you don't have this function here anymore. It's just saying, look, if she was conscious and capable, well, then she could make that choice, but she's not. And so what kind of choice do we allow to be made in that kind of a context? It is a way to eat away at some of the protections, right? This one basically says the statutes that say we won't even let you say in an advanced directive, even say if you had clearly contemplated, you knew you were ill, you knew there was a possibility something would happen, and you said, I've thought this through, this is my answer. So in some ways, it's eating away at, but it's just as much eating away at other kinds of decision-making authority, as well as parental ability to make decisions for children or even unborn children, right? I mean, they didn't listen to the father either in this particular case about what he would want to do. So it's a different kind of approach, and it's based very much on this concept that what we protect when we allow you to do things is an idea of autonomy. We can't really talk about autonomy in the same sense when you don't have a capable individual making any kind of a decision.
I will say two things, though, to that. So a lot of the reproductive rights sort of community has gone one step further and said, in KCV Planned Parenthood, the restriction was undue burden. This certainly is an undue burden on the right for termination. But the flip side, which is what Jessica was getting to, is that we as physicians generally don't do elective procedures when authorized by a surrogate decision maker, right? So your surrogate decision maker can't say you need a nose job or you need this toenail fungus cured or something while you're in a persistent vegetative state. They don't have the authority to give consent for that. And so an elective termination, which is was discussed, is part of that. And so we can't really rely on a surrogate decision maker like our husband to give consent for those.
However, given that this was now about he being the father, not the husband, and she was dead, then he becomes the next best person, the parent, to make decisions about
Best
his
interest.
and of the offspring,
Yeah.
the fetus.
But actually, I think we have to be careful about giving fathers surrogate decision-making capacity over fetuses. Because I think that's a very tricky and slippery slope scenario where in a lot of ways could invalidate the autonomy and bodily integrity that we've fought so hard to keep for pregnant women.
That is a challenge, but who would, since she would need a surrogate, if she can't, if she's not alive to make the decision, so it's not her body's issue anymore, it's not her rights, it's now the issue of only the fetus. The only living thing there anymore is the fetus. How would that invalidate her rights?
So I guess what I'm arguing is that he, as her husband, could make surrogate decisions for her, but not about an elective termination. But he also, even if we give him the rights to make decisions as a parent over the fetus, a termination is certainly not in the best interest of the fetus, and so that doesn't go along that line of surrogate decision-making either.
Interesting. I don't think of it as a termination. By withdrawing the life support, the fetus, who is terminal, continues to terminate. I don't know. Thoughts?
Professor Melvin in the back had a question, and then that's over. Okay, go ahead.
Just depends how good the question is.
Well, two questions. Well, real quick, what does ACOG say about this? Since this is OBGYN issue, what is the statement that the American College of Obstetrics and Gynecology has put forth about standard of care during pregnancy and situation like this?
So ACOG has reaffirmed a lot of its ethics opinions in sort of its media response to this. So it's ethics opinions on surrogate decision-making. There's another one, it's called Medical Ethics Decision-Making in the Law, which basically reinforces a pregnant woman's right to autonomy. From their legal arm, they have, stood poised, ready to pressure the Texas legislature should something go forward in courts, which it didn't rise to that level. So they haven't taken an official stance specifically on this issue because it didn't rise to needing that, but they did reaffirm their ethics opinions in favor of what happened.
And I think it's like a really big issue that the state of Texas decided to look at a textual aspect of the statute versus the spirit of law. Because if you think about a fetus, it's not viable at 14 weeks. The lungs are not mature. So I think of like if a mother was to die at, the fetus was 26 weeks, then the doctors would do everything they can to save the baby because that baby takes precedence over everything. But I think that the hospital looked at that and knew that, they overstepped their bounds because if someone was to die that's pregnant, immediately they would go into a C-section to remove the fetus. And if the fetus is 14 weeks, you can't give them any steroids or anything to survive. So I think it was just a bad situation, just in my opinion.
I wanted to throw one thing out here. What if this woman had an advance directive, and yes, it's revoked because she had the misfortune of becoming pregnant in the state of Texas or 31 others. But what if she explicitly wrote, this is what I was thinking about yesterday as I was kicking this case around, that she, if such and such happened, so you can envision a scenario like this, probably wouldn't envision brain death, but I would not want the pregnancy to continue. So you make it very specific to the fact of being pregnant and whether or not you would continue. And here you have, if she were conscious and able to make decisions, she'd be allowed, right, at 14. Why shouldn't we also honor that if she explicitly wrote it on an advance directive? And the forms aren't magic. We can alter these forms. What the forms usually give you, if you keep them as they are, is immunity if you act in accordance with the law and the form. But, you know, you can do an advance directive on a napkin, for God's sake. And we've had patients who've done that. So I would be interested to hear what the legal people think might happen if a scenario like that unfolded. I have no idea myself as to what might happen legally.
I mean, I think if you're in one of the states that has the statutes, they would say that is not a valid advance directive,
Can't do
and we
it.
would not abide
Yeah,
by it.
okay.
The other thing, I think to keep in mind a couple things here. One is the default, if you don't have a valid advance directive, is to default to a surrogate decision maker making decisions for the individual. So in theory, then you can kick back into either she's alive and this is an elective procedure, the surrogate decision maker can't make it, or she's dead and they're either making a decision as a parent of a fetus, for which it is true, is a very unclear legal area. We don't tend to make decisions for fetuses in utero without a living parent who is surrounding the fetus in utero who is also making decisions. So the idea of making it sort of as a separate decision for a fetus in utero, and maybe the fetal surgery context would be the closest we'd get to those kinds of areas, still not a great legal area. So it'd be interesting. I actually thought about the reverse, which is, what if you write an advance directive that says, no matter what happens to me, even if I'm declared to be legally dead, I think you have to do everything possible to keep my fetus alive. And then you end up with another interesting question, which is, hospitals don't treat dead people. They have no obligation to treat dead people. What if you have a live fetus encased in a dead person? Do you have any obligation to do anything in that context? As I said, insurance doesn't cover dead people. So would the health insurance system be able to say, look, we don't cover her because she's dead, and we don't cover the fetus until it's born alive, because by the terms of our policy, it's not covered by our policy. How would you sort of address the unusual reverse situation of saying you had to keep, how do we understand this? And it does really push us legally in trying to figure out, how do you understand this entity which does not exist as a person under our law generally, as well as exist as a person under some of our more specific statutes. So I agree, it's a really interesting thought experiment to try to come up with kind of how you pursue this.
So I've written and argued against the 14 states that have CHIP, which is how we cover children of low socioeconomic status for health insurance, but 14 states define children from the moment of conception on. So in that scenario, if she lived in one of those 14 states and had low socioeconomic status, then we would avoid the issue, but otherwise we wouldn't.
Even those focus on care provided to the pregnant woman. And so what they try to do is they try to cover the maternal care during the pregnancy. We still haven't had one that sort of tried to use some of these things to cover what's actually a much more significant expense to basically keep her circulatory system functioning through this entire time period. And so I think it would still even push those. But you're right. I mean, some of them have tried to play even around with that in a different context. So were there other hands before you go to Professor Melvin?
So I'm stuck on language. I get this way, but I didn't read when you put up the Texas one carefully enough. But does it refer to withdrawal of life-sustaining treatment of a pregnant woman, right? Because that therefore defines the woman as alive. In that, it doesn't say pregnant woman. If it says can't withdraw life-sustaining treatment, then you're defining the person as alive, and therefore stopping a ventilator from a dead pregnant woman.
Well, again,
it is murky. But that's what I was wondering.
It's murky because life-sustaining to who? The fetus. It's life-sustaining to the fetus at this point.
No, but if it says life-sustaining, you cannot withdraw life-sustaining treatment from a pregnant patient, that it defines that as then the pregnant woman is the patient. So if it says cannot withdraw ventilator support or, other things, but I think that language is really important in terms of how you apply it to the deceased.
Yeah, although I think if it says you cannot withdraw life-sustaining treatment from a pregnant woman, you could read it either way, whether it's related to the fetus or related to the pregnant woman. Because if you had a number of other things, I mean, we're already assuming you're going to call a pregnant woman who is not alive in the category of a pregnant woman. So if you're going to play with the language, I'd be willing to bet you can get people who play with the language either way. I think you could have done a lot of things in this case. They chose an odd way to address it on multiple legal grounds. I mean, it's sort of like it was risk adverse in one context, but not in a lot of others, which I think caused this to be it was sort of a naive comment by the hospital to say, we didn't want it to be a test case, we didn't really expect it to even get into the media. Like,
Right.
I'm sorry, really? Like, you did look to see what you were making a decision on, regardless of how you think the decision should come out. It should not have surprised you that it got attention.
And actually, the hospital lawyer addressed that. There's a New York Times article I looked at on it. So some of you might not think it's reliable, but that being said, the hospital lawyer's view is that the clear commitment of the legislature was to promote and protect the life of the unborn. And so he saw this as straightforward in that sense. I agree, though, if they really thought this wasn't going to become public, especially when you had a family. By the way, we haven't mentioned, you also had her parents. Her parents were in line, in agreement with her husband, Eric. The Machados is their name. So you had a whole family sitting there ready to make an issue of this, and they did. So.
I haven't looked at this in a number of years since I last did research in cadaveric organ transplantation, but I was really surprised that they could keep this body in whatever state it was kept in for that long. I mean, or, as Miracle Max said in The Princess Bride, mostly dead instead of completely dead, or I didn't see, I wasn't paying enough attention to see if there was a discussion of what shape the body was in at the end of that 2-month period. But I mean, can we do that now? Was this medically very unusual?
So I don't think we have a good account of what her body looked like other than some news articles that said she, her skin had looked gray and sallow, and but medically we can keep blood flowing through the uterus and through the placenta, which is the only organ that they really care about. So
Indefinitely?
I mean, we don't have great literature on it. This is a test case, but theoretically indefinitely.
Well, I have a situation like in Georgia. There was a case several years ago when I was in a hospital where the lady was brain dead. Her boyfriend shot her. She was dead, but she was pregnant at the time. I don't know if the baby was viable at the time she was shot, but the hospital did keep her on life support for several weeks. I mean, if you go in there and look at her laying up in the bed, she looked just like a patient who was asleep, and occasionally her body would jerk, but the doctor's like, she's basically dead. She was an incubator, but the baby her body ended up going into labor. She ended up having the baby, and her father came down and took the baby to raise the baby. So the baby survived. Mom was just dead. She was like an incubator, dead, but she looked like a normal person for weeks. They kept her alive.
And in most of those cases, it's because the family wanted they wanted the pregnancy to continue.
And in fact, if this had been very far along in a pregnancy, we probably would not have said to the family, here's a choice. Right? We might have just said, here's what we need to do. We probably would have either gone right ahead with the C-section, given her circumstances, or we might have talked to them about, is it worth us trying to buy a little more time when we're at the end? So if you have a clearly viable fetus, there are many decisions you can't make at that point, even if the pregnant woman had been fully capable of making decisions. So it's hard to say where you were in that particular circumstance. I think what was so unusual about this particular case was how early you were in a pregnancy that you'd even try to do anything. And in the particular case, whether or not, and that, I guess this is part of the whole, and I asked how clear are we on brain death, was the individual in the circumstance that you're looking at, were they actually brain dead or were they in a persistent vegetative state? Because in that latter, we have in fact maintained individuals for significant periods of time who were pregnant. They're not conscious and they're not able to respond, but their bodies are living. And we do have them on a variety of life support things depending on their current state, where we are feeding them and we are continuing to make sure that we, get to the point where the baby is born. So it's not, I think what really drove home this particular one was, there's really no question that she was brain dead, and really no question that the fetus was not viable for multiple reasons, which caused us to really question whether we could get, could you have even, or had you even gotten as far as a point where we talk about numerical viability, you would not have had a child born, you're very unlikely, at least, extraordinarily unlikely to have a child born alive in this particular case.
Yeah, that's right.
And that was before we even factored in, we knew that she was without oxygen for a long period of time,
Right.
which meant fetus was without oxygen for a long period of time.
This is just a hypothetical. So had this the fetus in this case been numerically viable, but you mentioned it had a lot of congenital defects. So where does I think I have a question about the viability. So is it numerical viability, or you said that likely the defects that it had were not compatible with life? Like, how would that have played out, do you think? I mean, this is purely hypothetical, but.
Well, you can do late-term abortions if the fetus is incompatible with life, particularly when there's a risk to and usually when there's a risk to the mother to continue the pregnancy. Again, it's, the comparison of who's at risk.
And these end up being called medically based abortions, and there's a conflation in the use of the term elective, because of course you don't have to do the medically based abortion, but it's not elective in the sense that, plastic surgery is elective, and we've seen cases like that. I think there is an irony here too, that we got to 22 weeks, which, whatever was going on, at 14 the fetus was less viable than at 22.
But I think part of that is also just our inability to measure better in utero. So most of our ultrasounds that would pick up advanced hydrocephalus, advanced cardiac disease, aren't technically possible until 16 to 17 weeks. So when she was found down, we probably didn't have this information that this fetus wasn't viable, which is why it came out through the media, I think, later, because I think the physicians probably didn't know about it until a few weeks on, which I think is further complicating because by then the decision had already been made to continue this life support.
I know oftentimes when there is a specific sensationalized through the media event, particularly around a controversial issue or something that people care about, we start to see policies popping up in different states to react to it in a proactive way. Is that any of that happening? Do you know anything being introduced or talked about being introduced, and where they might be leaning to changing their policies?
Great question.
So I haven't heard anything from the legislative arm of ACOG, but that's generally a reactive process. So that's even one more step of reaction. But I'm not sure if you've heard anything.
Yeah, I haven't either. I mean, one way to see it is that they weren't even, what they were doing was not in accord with the statute they had, so there's really nothing to change. Another way is to say, well, it was a misinterpretation of the statute, and therefore we need to clarify what we intended to have happen. It is as a politically sensitive topic for legislatures to take up as it is for people to talk about. They may not want to. I mean, the states that have the statutes may say, oh good, we got them through, we're not bringing it up again. Because this kind of a case is viewed as the egregious side of it, and we don't want to have the bad press go along with what we wanted. And people on the other side may say, look, our state passed this statute. We're not going to win trying to get rid of the statute, even in a horrible case. So we may as well sort of just build up, our evidence for why it should be interpreted differently. So I don't know if you will see an effort in the same way we saw it, for example, with the Octomom, where all of a sudden everyone was focusing on, how do we regulate fertility treatments? I don't know if you will see it here, just because especially also going into election years, you tend not to see legislatures in states that have elections want to take on, this will be a hard case for both sides, right? The side that wants the statute is going to have to explain why it happened in this case with the whole family saying no of a woman who was brain dead being kept alive. And the side that wants to say this was egregious in any case you're doing it has to explain why in a more sympathetic situation you wouldn't this was just a misinterpretation of the statute. Of course we want it applied correctly. So I don't know if we'll see it or not. It'd be interesting to watch. So, any final questions? All right, so this is one of our Zaremski Law Medicine sessions that we have. We actually will have another one come up in April. We'll send you information about it. And I'd like to just take a chance to thank our panel so very much for coming in and speaking with us.
I'm glad somebody prepared slides.
I was like, didn't you get the email?